afternoon, Your Honor. Good afternoon, Dr. Von Gurnett.
Good afternoon, all.
Your Honor, before we get started, it was suggested to me that we might target for a short break at approximately 3 o'clock, if that works for Your Honor.
Very good. We might, you think can go 2 to 4? Or do we? Yeah.
Very good. I'll watch for signals. So Dr. Von Gurnett, where we left off, you are explaining your methodological point on your slides at slide 4. Was there anything further about the methodological point you wanted to explain to the court before we move into your discussion of assumption 1?
No, I think we can move on.
On slide 5, you introduce assumption number 1. Could you take the court through your points with an emphasis on the methodological point that you explained before the break?
Yeah, so as you know, as an ethnohistorian who reconstructs the past for a living, I always, try to entertain as many different assumptions as possible in order to see what happens in the outcome if you use one as opposed to another. And so under this assumption, which, as I said earlier, is derived from my other opinions and which I think are viable alternative assumptions, at least from an ethnohistorical standpoint. Under this assumption, the Crown understood the augmentation clause to mean that the annuity payable under the treaty had a maximum upper limit in an amount allowing an increase in a pre-augmented annuity sufficient to pay $4 per capita. And as we saw from my testimony this week, that was in fact the underlying assumption in all of these Crown actions. The only unique characteristic of the Robinson Treaty under this assumption was that the indigenous annuitants would not enjoy the full annuity until a certain fiscal condition was met. Otherwise, it's the same sort of thinking that underlies the pre-1850 treaties and indeed the numbered treaties as well, for that matter, because there's also a maximum upper limit on them as well.
Is it a maximum upper limit or a fixed annuity?
It's yes, it's a fixed annuity. It does not have, you're correct to make the distinction, because it is a fixed annuity, but because the number treaties do not have provisions for time of treaty population.
Well, they don't have provisions for augment changing.
Exactly.
It's fixed.
Yes, it's fixed.
So nobody cares about how it is a different way of augmenting,
But it is
because there is no augment.
It's fixed in the per capita annuity,
Fixed in
but
per
it is
capita.
not fixed in the total amounts because it rises with population increases.
It's based on actual population.
That's right.
Okay, got it.
Dr. Von Gurnett, in the third sub-bullet, you talk about Anishinaabe understandings. Could you elaborate on that point?
Yeah, so under this assumption, at least some Anishinaabe understood their entitlements under the treaty much the same way as Crown officials. And that is just, that becomes a viable assumption because, as I said, these various petitions that the Crown actors were reading or had received did not allude to any further monies beyond the $4 per capita. So this is these are the components that underlie assumption number 1 or comprise assumption number 1. So now you take that and you apply it to the current task, and which is what I did. So on the next slide, on slide 6. So you may recall that there was some division on the issue of whether the treaty obligation necessitated paying augmentations from the proceeds, and whether the augmentations were in the augmentation clause was only there to establish the threshold when those augmentations were payable. And as I said earlier, the SCC later ruled that the augmentation clause did not mean that the increases were to be paid out of the proceeds. And the Judicial Committee of the Privy Council unanimously agreed that it made no difference to the Indigenous beneficiaries. But in any event, I concluded in my report that the Anishinaabe understood that their treaty annuities would in fact be drawn from the proceeds of the lands. And in this sense, the Anishinaabe understood that they were sharing the wealth that they thought was being generated in their surrendered territory. So under assumption number 1, the upper limit of the sharing would be 100% of the net proceeds up to an amount sufficient to increase the pre-augmented annuities to the point where, upon division into shares, every annuitant would receive the $4 annually. So this, even under this assumption, that it's a form of sharing, because the Crown would enjoy the gains above what was needed to pay the maximum treaty obligation, and at the minimum retain an amount needed to cover costs. So even though there's the 100% of the net proceeds are going to the Anishinaabe, the Crown still retains the rest. So that's sort of the outcome of adopting assumption number 1, and then this becomes sort of a useful way of understanding how the assumptions connect to the conclusions under assumption number 2, which is in slide 7.
Thank you, Doctor. So we're on slide 7, and this discusses your assumption number 2. Could you please take the court through the assumption?
Yeah, so this assumption is, as I said at the beginning of my testimony in respect to this report, I was asked to read the Court of Appeal decision. And so I derived this assumption from the paragraphs I cite in slide 7. And I don't know whether I'm correct or not, but this was my understanding of the Court of Appeal. It had at least 4 components. So first, the $1 the £1 or $4 cap referred to in the augmentation clause applies only to quote unquote distributive payments to individuals, and not as a limit on the collective annuity. And then secondly, the collective annuity, which in the RST was £500, is subject to an unlimited augmentation. And thirdly, the collective annuities would increase so long as the economic condition was met. And then fourthly, such sharing of wealth was central to the understanding, aspiration, and intent of the Crown, as well as the Anishinaabe. So whether I got that right or wrong, I don't know, but that's my reading of it. Now, on this interpretation, the revenues from the territory greater than the amount necessary to augment the annuity to $4 per capita could be shared between the government and the Anishinaabe in some kind of mutually agreeable proportions. And so on page 27 of my report, I give a hypothetical scenario because I wanted to understand in my mind how this would work in practice. And since this literally never happened, I can't point you to an example from the record. So I had to come up with a hypothetical example of how this would work. And that's what I gave on pages 27 to 28, just using numbers that are, round numbers and are easily digestible in terms of its math.
Thank you, Doctor. On slide 7, second bullet, you use the phrase shareable excess. Could you tell us what that means?
Yeah, so in my hypothetical example, there was a number that came that arises from when you do these calculations. And so the excess amount at the end of that calculation is what I refer to as the shareable excess. Right, to reach the shareable excess, you need to do some calculations first. And so that's what I did. And so my nomenclature is the shareable excess. So this is the amount that would, under this assumption, be subject to sharing between the Crown and the Anishinaabe.
Thank you, Doctor.
Is the shareable excess anything other than revenues less expenses?
Well, you have to go through my example because
Is this just your last bullet point on slide 7, or have I?
I think the best way to do it is to actually go through my example and then you get the picture, right? So let's say you have.
So Doctor, we're on page 27
Of my report,
perspectives
yeah.
report.
Oh, okay.
Yeah, if we go to page 27.
Go ahead.
So let's say that in a given year, the RST annuitants total 2,000 people. And the surrendered lands produce no revenues at all. Each individual share of that 2,000 pre-augmented annuity would be $1, right? Then the following year, the government received 6,000 in net proceeds from the lands, thus allowing the individual share to be augmented by $3 to reach the $4 cap. If in a subsequent year, the government received 8,000 in net proceeds, the additional 2,000 would also go to the Anishinaabe. However, unless the graciousness clause was invoked, this could not be used to increase the individual annuity to $5, but would be placed in a separate annuity fund account reserved for the enjoyment of the collectivity, referred to in the treaties as the chiefs and their tribes. Alternatively, the 2,000 or whatever the excess amounted to could be shared between the government and the Anishinaabe in some mutually agreeable proportions. For convenience, let's call this amount the shareable excess.
Got it. Thank you.
Dr. Von Gurna, the passage you just took us through in your report, that's your understanding of the Court of Appeal decision, correct?
Yes, if I understand the reasoning correctly, if you hold assumption number 1, this is the outcome. Now, I may be right or I may be wrong, there may be other ways to do this, but this was my best effort to find what in practical terms does this really mean?
Doctor, you just indicated assumption number 1. Did you mean assumption number 2?
I meant assumption number 2, of course.
Thank you.
So another way to put that is that first the Crown looks at net proceeds, and to the extent they hit $6,000, that would allow, with a 2,000 population, that would allow an increase of the augmentation by $3 and therefore hit the $4 maximum.
Yes,
So you then say your understanding is that the next calculation is whatever net proceeds there are after $2,000
yes.
goes into a new fund
Well,
that could be accessed by the graciousness clause.
well, you need to distinguish, because if you can't go beyond $4, if
That's what I said.
yes,
Your example is
yes,
that after the $4,
yes,
the net proceeds
yes,
go into an account that can, and access to that account
is for the collectivity.
can be triggered by the graciousness clause. Is that what you're saying?
No, unless the graciousness clause was invoked, this could not be used to increase the individual annuity to $5,
Okay,
right? Unless the graciousness clause was invoked, which would allow it to go to $5, right?
okay, so then I want to step back,
So you don't need the graciousness clause to.
that it still goes into an account.
Yes,
And
yes,
that account is accessible. How do you say?
by what the treaties say, refer to as the chiefs and their tribes, right? So the collectivities, the individual bands,
Okay,
right? Because if you can't distribute it per capita, as you usually do with the $4, then where does it go? It has to go somewhere. But it has to be distinguished from the amounts that are being paid out per capita.
but you say it has to go somewhere.
Well, you mean if.
I'm not arguing with you. Is
Yes.
that is what you're saying?
Yes.
Okay,
Yes.
Dr. Von Gernert, at slide 8, you talk about the consequences of the adoption of assumption 2 with respect to the Anishinaabe perspective. Could you take us through that, please?
Yeah, so once you adopt this assumption number 2, as an ethnohistorian, I can only say that, you know, we start entering a realm of speculation on a very high level of magnitude in respect to the party's understanding of sharing. Because what happens now is any Anishinaabe principles, perspectives, understandings, expectations can easily be construed in a manner that allows the rationalization of any amount up to 100% of the shareable excess. Because you've now opened it up to an infinite amount. That has no cap and no limit. And so, trying to understand how much of that shareable excess would be understood as shared and in what proportion involves an ethnohistorical exercise that is no more than speculation. So, for example, when I read the Court of Appeal decision, I noted that the plaintiffs at stage 1, according to the Court of Appeal, had argued that a fair share would be 100% of net Crown resource revenues. So 100% obviously just on logical grounds can be ruled out in the sense that it doesn't constitute sharing. If anyone gets 100% of something, it's not sharing. But this still leaves open a wide range of available shareable excess.
Doctor, the final bullet on slide 8, you pose a question. What is that?
Yes, in my report, I posed what I think is a very fair question. If the Anishinaabe in 1850 were expecting a lesser share than the 100% of the net proceeds that were asked for in a 21st century courtroom, what does that say about change and continuity in Anishinaabe perspectives? And I raise this as a fair question because, as we'll see, Dr. Dribbin basically sees Anishinaabe perspectives or he sees Anishinaabe culture as a monolithic entity that basically has a belief that informs their actions no matter what time in history. And if that was so, we have to account for differences in expectations between the 21st century and 1850.
Doctor, on slide 9, you talk about human universals.
Yes.
Could you tell us how human universals factor into your perspectives report?
So as anthropologists, we obviously have great interest in human universals. We've studied them at least since the 1940s and have continued to have an interest in, despite the fact that most anthropologists are relativists in the sense that they see every culture not in terms of a universal, but rather as a discrete entity that's different from all other cultures. So we've always had this I mean, the use of human universals to illuminate the specific is a very difficult intellectual exercise, as is the reverse, the use of individual instances to illuminate what might be human universals. And so the problem with resorting to human universals is that they lack the required specificity to help us understand the expectations of historical actors in 1850. And as we'll see, Dr. Dribbin does resort to some human universals, and I don't think that's helpful at all.
Doctor, could you give us a definition of human universals?
Well, things like reciprocity. In every culture that known to anthropology, reciprocity is a key element of morality. And in every culture known to anthropology, trade or the exchange of one kind of good or service for another is also a human universal. Sometimes some cultures have more trade. In other cases, they have very little. There are even cases where they only trade with one another, such as what archaeologists refer to as the Paleo Eskimos, for instance, who were so isolated from other cultures that the only trading they had was with each other. So those are the kinds of attributes of our shared humanity that are universal to all.
This is not meant to be an argumentative question, but if one heard the evidence earlier in this trial about the rational, greedy, universal human, the existence of whom underlies economics and capitalism, it would be hard to accept that that there is a human universal presumed in every culture of reciprocal sharing. I'm not,
Yeah.
neither a student of economics nor of anthropology.
Yes, it depends on how you define. It depends on the definitions, because let's say, for example, we think of only in terms of profits. Not every culture thinks in terms of profits.
It turns
Right.
out that some do, though.
Some cultures do, yes.
And
Or
we
some
were-
humans within cultures do. But there are cultures all over the planet who engaged in a mode of subsistence and had a mobility that didn't allow the accumulation of wealth, because you simply, for practical reason, you simply couldn't carry off huge amounts of stuff. And so everybody had the same. Nobody was any different from, and the chiefs were, had the same amount of goods, if that's the measure of wealth, as everybody else, right? So, but once you get into state organized societies, then you do have disparities in the understanding of wealth, and you've got elites and you've got priesthoods and so
We're
forth.
going way too far. I'm talking about assumptions of what you call human universals.
Yes, there are human universals. There's no question about that. There's many human universals.
There are many,
Yes.
and some of them aren't the same. But we still call them universals. That's all I'm trying to understand.
No, there are human universals involving traits, practices, which are shared by every culture known to anthropology. I mean, there's an entire book by Brown that was published in 1993 called Human Universals. It's an anthropologist who compiled, in fact, one of his chapters is called The Universal People. And it is sort of a combination of all of the human universals put together. And so this hypothetical human culture has all of them.
Okay. Doctor, could you give a couple of examples of human universals that Dr. Dribbin relies on in the report that you read and responded to?
I think I allude to that later on in the slides when I talk specifically about Dr. Dribbin's opinion. There was, for example, that this idea of happiness.
Thank you, Doctor.
But I'll address that in a later slide.
Thank you, Doctor. Still on slide 9, second bullet, you talk about being cautious of generalizations. Could you elaborate on that point, please?
Yeah, so on the one hand, human universals are not particularly helpful because they usually don't have the specificity. But on the other hand, identifying that as something that is unique to, let's say, Anishinaabe culture in 1850 might not help either, because anthropologists learned long ago to be very cautious of any generalizations about entire groups based on select voices. It's a big anthropological problem, because anthropologists, especially cultural anthropologists who go into the field and they ask certain informants, what's your culture? They end up getting these select voices from individuals, and unless they have a huge sample of informants, they don't really get a very good sense of what, the characteristics of the culture is. It's in part a sampling issue, but it's also a consequence of humans having considerable variability within their own cultures.
Thank you, Doctor. The third bullet, still on slide 9, talks about 19th century council fires. Could you explain that point to us, please?
Yeah, so I want to impress upon everyone that treaty commissioners who treated in these treaties did not meet with cultures. They weren't meeting cultures, they were meeting individuals. And these individuals had varying perspectives, understandings, expectations. Some of the leaders that the Crown was treating with were informed by their personal beliefs as well as mandates that had been given to them from their particular Indigenous group, and those might have been quite different from other leaders and their mandates and their personal beliefs and so forth. So it's a fallacy. Again, it's a major one to think that the other side of the council fire was some kind of generic Anishinaabe human. There is no such thing. These are all individuals who have their own perspectives on things. Some of it may be informed by a wider Anishinaabe worldview, or Weltanschauung, if you will. Weltanschauung, that's a German, commonly used in English now as well, but it's originated as German. It's a worldview. But, you know, people's actions are not just determined by their culture. They're also determined by their personal experiences and by whatever agendas there might be within their particular subgroups.
So individuals have their own perspectives informed by their group worldview.
Yes, in part by their group worldview, but also in part by their own personal.
Right, they have their individual perspectives
Yes.
informed by a group worldview. Individual perspectives come from their own individual experience.
They are informed both by cultural predispositions and by their personal experiences and views that they acquired irrespective of the culture in which they live.
Thank you.
Doctor, at slide 10, you give an example of treaty number 3.
Yes.
Could you frame this up for us by describing briefly treaty number 3, who the parties are, when it was entered into?
Yes. So treaty number 3 is I think, a suitable analog here. So Treaty 3 involves the lands immediately to the west of the R8ST territory. That is, it's west of Thunder Bay. It starts at the Haida Land and continues throughout much of northwestern Ontario. North of the US border, which is the Rainy River region. And these were Anishinaabe peoples. These were the peoples that Dawson was very familiar with because he was working in that region. And as a consequence, Dawson became one of the commissioners for Treaty 3. These people had close kinship connections with those at Fort William, the Haida land being merely a jurisdictional boundary rather than a cultural boundary. And indeed, there were some individuals on at the other side of the Haida land who also, after the Robinson Treaty was signed, wanted to join in the annuity payments, because they said, you know, they're even though they live beyond the Haida land, their traditional territories had also been in the RST territory. So these people are closely related. They speak the same language, although in the literature they're referred to as the Saulteaux. And they lived in the same sorts of small bands, and had a similar mode of subsistence.
Thank you, Doctor. And in the first bullet, you say the negotiations leading up to the signing of Treaty Number 3 illustrate the point. What is the point you are intending to use Treaty 3 to elucidate for us?
Yeah, so if, let's say, all Anishinaabe basically understood sharing in the same way at all times and in all places, then we can test that. That's a testable hypothesis. And Treaty 3 becomes an example because of the similarities I just articulated. Now, Treaty 3 took years to come to terms. They started discussions already as early as 1869, 1870. Formal talks were started in 1871. They continued in 1872, and only came to a conclusion in 1873. So it was a very long process. Treaty 3, Your Honor, was supposed to be Treaty Number 1. It was supposed to be the first of the numbered treaties. It was the first post-Robinson treaty that would extend the extinguishment of Indian title to allow the connection between the old Upper Canada and the Red River settlements, which were then in what is now Manitoba. So this was an important sort of part of the puzzle. However, they eventually gave up temporarily negotiations and ended up doing what are now known as Treaties 1 and 2, which were in what is today Manitoba. So they skipped over this in the meantime. And so that's why it became Treaty Number 3. So by the summer of 1872, well, I should say the reason why this was a problem is because there was a difference of opinion on compensation. And there were divisions within the Anishinaabe ranks about what to accept or what to reject. And so it wasn't just a difference between the Crown and the Anishinaabe when it came to compensation. It was also a difference between bands within Anishinaabe, within the Anishinaabe region. And so by the summer of 1872, some of these Anishinaabe bands were inclined to treat with, on the terms that the government offered, although they were opposed by others who were holding out for a better deal. And the government at the time was only prepared to provide no more than a $3 annuity. And the other terms that you're offering as well were considered by the Anishinaabe to be unacceptable. But there were, by 1872, some bands who were inclined to treat on those terms, and they were opposed vigorously by others who were holding out for a better deal. And the record suggests that that by the evening of July 16th, 1872, when these proceedings were taking place, the whole thing nearly collapsed into a brawl among the Anishinaabe delegates. The spokesman for Rainy Lake tried to speak, but was threatened to the point where he reached for his knife. And then, one of the crown representatives fled to fetch his revolver, and there's another one who was fingering his pistol, and it was a very tense situation, and rather graphically described by a reporter who was on site at the time. And these kinds of tensions persisted among the Anishinaabe, for some time before finally they agreed to treat with the Crown on terms that I'll discuss later.
Thank you, Doctor. You told us about an episode on July 16th, 1872. Could you help us by expressing what relevance should we draw from that episode with respect to your point about differences of opinion?
Well, yeah, you mean 1872?
Yes.
Yes. Well, I mean, this is sort of a dramatic example, but it serves to illustrate that, when you think of Anishinaabe perspectives on what is a decent compensation, there are differing views to the point where, people nearly come to blows. This was not quite the case with the Robinson treaties, but if you're going to make generalizations about what Anishinaabe views are, then you need to understand, that Anishinaabe people are human like everyone else, and they, within their own cultures, have different perspectives and different expectations about these matters. There is no monolithic Anishinaabe culture that informs what we today should expect their expectations were.
Thank you, Doctor. And on slide 11, you contrast the scene in 1872 at the Treaty 3 Council with the Robinson Treaty Council. Can you take us through these points, please?
Yeah, so things are not as dramatic in 1850, but it's still obvious, even in 1850, that there are different views held by members of the same Anishinaabe culture on what was an acceptable annuity quantum. So we know from extensive evidence that I gave and others gave in stage 1, that there were 21 chiefs, about the same number of principal men, a large number of band members were present at the council, and they all preferred Robinson's offer, according to Robinson's testimony, except Chingwakons and Nebinagoching, two RHT chiefs, who insisted on $10 per capita. And the RST Anishinaabe signed the treaty first, and then Robinson prepared the Lake Huron version for signature. The reason he prepared it was because he felt that a large majority, as he put it, had agreed to its terms. So he thought, I'm just going to put this out there. We'll see, if this large majority agrees to it. And so Chingwakons and Nebinagoching eventually signed the Lake Huron Treaty after seeing that these other chiefs had come forward to sign. And moreover, there's no question that different views on annuity quantum prevailed, because we also have the evidence of Vidal and Anderson back in 1849. Your Honor, you may recall that they went through this expedition that started at Fort William and proceeded along the shores of the Great Lakes to Penetanguishene. And throughout that region, they found what they referred to, quote, some diversity of opinion, end quote, regarding the amount of the annuity and the mode of payment. One chief had demanded $30, another had demanded $60, another demanded $100 per capita. So these are quite different views of, you know, the amount that they expected to receive in annuities from the surrender of their lands.
Dr. Von Goethe, on slide 12, you can continue your points about diversity of views.
Yes.
Could you please take us through these points?
Yeah, so when we look at both the records of the Robinson and the Treaty Number 3 councils, you know, I conclude as an ethno-historian and anthropologist that there's no such thing as a single Anishinaabe perspective that can be enlisted in, you know, to illuminate or be in service of the task that Dr. Driven had been assigned.
And this no single Anishinaabe perspective is different from universal, how do they call it?
Human universals.
Human universals.
Yes, well, I mean, the human universals are of no assistance because by virtue of being human universals, they are not distinctly Anishinaabe, right? They're not a distinctive characteristic of Anishinaabe culture, but the unique characteristics of Anishinaabe culture cannot be drawn from looking at individuals who are, let's put it this way, if the same Anishinaabe culture is producing views that range from $30 to $100, right? And what does that tell us about a particular Anishinaabe perspective? It's not really a particular Anishinaabe perspective. It's a
So the difference in amounts that they put forward is an example of how they do not share the same perspective.
yeah.
Okay.
Dr. Von Goethe, on slide 12, in the second bullet, you talk about the list of demands from Treaty 3. Can you take us through that, please?
Yeah, so I'll be talking when I specifically address the points in Dr. Driven's report. I show, the comprehensive list of demands, and it's probably best to talk about that when I deal with the Driven report. I'm just sort of giving a heads up here, saying that I'm going to return to this Treaty 3 example because it really illustrates this point well. So at the end of the day, if we adopt assumption number 2, it generates what, in my view, is an insoluble dilemma that is perhaps best resolved by having the parties with an interest in the shareable excess sitting down and hammering out an agreement through negotiation. There's really nothing, in my view, that an ethno-historical approach can contribute to that. There's no amount of anthropological or ethno-historical or other evidence about Anishinaabe principles or perspectives or understandings or expectations that's capable of illuminating the issue, at least not with a tolerable level of certainty. Because as I understand it, at some point, somebody has to, make a decision as to what the share is. And that's pretty specific. If that's the task, I'm afraid that this kind of exercise is not going to help that task. You cannot draw from the ethno-historical record and the anthropological record a solution to that dilemma.
Doctor, when you say that dilemma, what do you mean?
Well, I mean, as far as I understand it, is no one really knows what the parties would have understood as being the quantum of the share that each would get. And if that's the task, if you're trying to identify what that is, you know what, you're not going to resolve that with this with the record that we have. Whether that record comes from modern understandings of Anishinaabe principles and perspectives, or whether it comes from a reconstruction of their past experiences. The fact is that if you're drawing from either human universals or from an alleged cultural predisposition, and then using that to illuminate the specific case in 1850, then you're going to have to also explain why it is that the expectations were totally different in another Anishinaabe context.
Doctor, I believe this segues into your specific response to Dr. Paul Dribbin. And Your Honor, just for the record, the Dr. Dribbin report is Exhibit 14 in the trial record.
Thank you. I do not have it in front of me. Do I need it?
I don't believe so, Your Honor.
Okay, thank you.
And if we do need it, we'll put it on the screen.
Thank you.
Dr. Von Gernert, slide 14 reiterates Dr. Dribbin's opinion.
Yes.
How would you like to approach this slide?
Well, this is Dr. Dribbin has conveniently offered his opinion in the form of these 4 summary statements that you see on the screen. And what I did is I just simply copied them onto the screen so that we all know what I'm responding to. I don't know if we need to reread them, but they're in his report. They are reproduced in my report, and they're on the slide 14. I don't think I've mischaracterized them anyway. I simply copied them out of his report.
Thank you, Doctor. Do you see a distinction between numbers 1 through 3 on this slide and number 4 on this slide?
Yes. Number 4 is the one that deals with Crown officials. Whereas the other ones deal with the Anishinaabe beliefs or expectations or anticipations. That's the main distinction.
Thank you. And I believe in your slide deck, you deal with those separately. So perhaps we can turn to slide 15, where you discuss numbers 1 through 3 from Dr. Dribbin's report. Could you take us through your perspective on numbers 1 through 3 of Dr. Dribbin's opinion?
Yeah, so when I read the first 3, to me, at first blush, they didn't seem to be based on any ethno-historical evidence or any kind of sound methodology, but they read more like a modern wish list that takes advantage of the unlimited revenues that are made available under the assumption number 2. And so in that sense, there's no real introduction of historical evidence. It's basically a circular argument. The reasoning inherent to all of this is circular. And as for my second point, the supposed Anishinaabe anticipation that the Crown would provide them, quote, a share that would be generous but not overwhelm the Crown, which is what he refers to in his point number 3. That kind of conclusion does not assist at all, in my view, in quantifying compensation. And it's also inconsistent with the RST plaintiff's suggestion that a fair share would be 100% of net Crown revenues. And so again, I think it's very fair to ask, if in 1850, the RST Anishinaabe expected the Crown to provide a share that would not overwhelm the Crown, that would be generous, but not overwhelm the Crown, then what is it? And yet in the 21st century, there's a claim that it's 100% of net Crown revenues. What does that really tell us about change or continuity in Anishinaabe perspectives, right? You can't have it both ways. You can't be 100%, but on what basis and how do you quantify something that is generous but not overwhelming? It just doesn't help. I mean, this is all fuzzy stuff. In my view, I tend to be a little more logical about these things. This is all kind of fuzzy logic. It's
on slide 15 still, Doctor, in the 4th bullet, you talk about a realm of speculation. Could you elaborate, please?
Yeah, as I said earlier, again, this is an example of how something can be construed in a manner allowing any amount of the shareable excess to be shared in whatever proportion you please, because what is something that's generous but not overwhelming? I mean, you can come up with any figure. It's not helpful. It's all speculative. This is just sheer guessing.
Thank you, Doctor. On slide 16, you have in the heading the words flawed logic. Could you explain your point with reference to Dr. Dribbin's opinion?
Yeah, so here, there's evidence in his report that involves human universals, and for example, this sharing is linked to what Dr. Dribbin refers to as sensations or feelings, such as happiness or experiencing the way of a good life. These may all be Anishinaabe ideals and goals and parts of their culture, but this is the problem with recourse to human universals. It doesn't help us because that's a given. If all humans strive for happiness and the way of a good life, it's not something that's uniquely Anishinaabe. And so I don't see how that is of assistance.
And you're saying that is a human universal.
Well, absolutely. I mean, I don't know of any cultures that don't strive for happiness. I mean, perhaps, perhaps there are. I've been an anthropologist for,
Do the anthropologists study the group that says the guy with the most stuff at the end wins? Like, isn't there a difference in worldviews?
well, I don't think Dawson or Boron.
Well, that wasn't my question.
Yeah, but I mean, they're of a different culture. I'm just thinking of a different culture than Anishinaabe, right?
I'm not, I'm just asking this question. You say it's that each of these characteristics that Dr. Driven identified, you say they are universal, human universals,
Yes, well,
and that every single culture shares them.
well, yes, I mean, happiness, what humans do not. I mean, you have to ask yourself, not the question of whether it's a human universal, you have to ask the question of what humans do not strive for happiness, no matter what culture they come from. So how does that help us with a uniquely Anishinaabe perspective?
I'm not at your second question. How does that help us? But you say that's a human universal.
Well, what I'm saying, let's talk of it as a generalization, all right? Irrespective of whether it's demonstrably a human universal. First of all, I have to say that the concept of human universals is in and of itself based on an assumption that all of the societies that anthropologists have studied in history have those characteristics. The fact is, we don't know about 99.9% of human history, right? We have never had access to that database. So we already have, only a subset, which is the one that anthropologists can study of humans that are documented, right? So it is, in a sense, and these are assumed universals rather than known as a fact in that sense. But my point here is in the flawed logic is that these kinds of generalizations, which are so broad that we can even call some of them human universals, cannot illuminate the specific task. And then on the other hand, Dr. Dribbin does rely on more specific cultural traits. And in his case, if I understand him correctly, these are more specific. They're often religious beliefs, but they're presented as if they are held by every Anishinaabe person at all times in all places. And
That's a different criticism, isn't it?
yes, it is.
I don't want to throw you off your line.
Yeah, that's a second criticism. The first criticism is that methodologically, from an anthropological point of view, you cannot. Well, it's unhelpful at the very least to try and illuminate what is Anishinaabe culture by reference to human universals.
Okay.
Right. The second point is that when Dr. Dribbin does rely on more specific attributes, such as religious beliefs, which are not universal, i.e., there are many different religious beliefs and they don't all involve the same thinking. These are presented as if they're held by every Anishinaabe person at all times and places.
As I said, sir, I'll leave it to council to bring you to what your second criticism is. I didn't mean to introduce that.
Your Honor, the second criticism is actually on the same slide.
Right,
Yes.
monolithic.
So, yes, so Dr. Bungern, it is now in the second bullet on slide 16.
Thank you.
And Doctor, I believe you're about to get into plurality of religious views
Yes.
in the 19th century. Could you explain that, please?
Yeah, so, I mean, Dr. Dribbin's inferential reasoning, because that's what he's using, is it's inferential reasoning, requires this as a basic assumption. If these beliefs that he tells us are Anishinaabe beliefs, they're kind of quintessential attributes of Anishinaabe culture, if that is true, then the reasoning requires as a basic assumption that all Anishinaabe persons at all times and places have this. And that's simply not true. That's demonstrably false. Anishinaabe peoples were very diverse in their religious views. So for example, when he uses when he refers to the example of the teachings of the grandfathers, which is derived from a book by Benton Benai, that is specific to one of the Anishinaabe religions, held by a number of Anishinaabe peoples today and also in the 19th century. But it is not an Anishinaabe view writ large, because Anishinaabe peoples belonged to many different religions. There was a religious plurality in the 19th century. I took a lot of time researching the Nipigon band in Lake Nipigon area, who are an RSD band. And I was surprised by how much religious diversity there was already in the 1850s. And I need not remind, or perhaps I should remind, that, you know, even back in the 1830s, Anishinaabe peoples throughout Upper Canada were exposed to a tremendous diversity of religious beliefs. Many Anishinaabe in Upper Canada were actually Methodists. Some of the most famous Anishinaabe leaders, like Kakwanakwanabe, or Peter Jones, who was the chief of the Mississauga of the Credit, he was a Methodist minister. And at Garden River, Shingwakons, he was originally of the Maide belief, but he later noticed that the Methodists were starting to proselytize among his people. And then the Anglicans showed up, and the Anglicans continued because the Methodists didn't have the resources anymore to send missionaries. But the Anglicans, they stuck around in the Sault Ste. Marie area. And Shingwakons himself, after he had one of his children suffered from an ailment, and his own religion did not cause any relief. And suddenly an Anglican showed up, and intercessionary prayers resulted in the recovery of the child, and he converted. Shingwakons himself became an Anglican. So, religious diversity, which is well documented. There's an entire book by Vexi that was published on religious diversity among the Anishinaabe in the 19th century. So one has to be careful again here of sort of using select voices about what an Anishinaabe perspective is, and then using inferential reasoning and suggesting that this is common to all. And then using that to illuminate in turn the specific events of 1850. So my overall criticism on this point is that the methodology is flawed in that it enlists the particular, that is an individual's religious or other views, to infer the general, that is a monolithic Anishinaabe perspective on sharing, and then enlist the general to illuminate the particular, that is the meaning of sharing under the RST Treaty. The whole thing has an inherent circularity to it, and in my view is ethno-historically flawed, because you cannot enlist the particular to infer the general and then use the general to illuminate the particular.
Thank you, Doctor. Could you perhaps illustrate these points with reference to Treaty 3? And I believe you do that at slide 17.
Yes, so this is where I return to Treaty number 3 again. So the logical consequence of regarding Anishinaabe peoples as if they were and are a monolithic society is that we should find similar beliefs and expectations in other contexts. So I'm not going to go over again why the Treaty number 3 is a good comparison. Now, one of the other things that is interesting about Treaty 3 is much like the RST signatories, the Treaty 3 Anishinaabe were aware of the valuable minerals on their lands, and they used this knowledge to press for the best deal possible. Now, if they had been presented with an open-ended, unlimited share of all the proceeds from all the minerals that they said were rustling under their feet, there's no question. I mean, any reasonable person would have accepted that. They would have accepted that if that proposition had been given to them, if that offer had been made. But that's not what the government offered. But more importantly, this is not what they themselves asked for. We have, in fact, in the archival record, preserved their written list of demands, which they said, if these demands were granted, they would immediately sign the treaty. This list was prepared years before the 1873 treaty. In fact, it was prepared as early as 1869 and then represented during the final negotiations in 1873. This was an exceptionally detailed list of what they expected to receive. They itemized 20 distinct demands, including a $10 annuity and a large number of specified goods. Your Honor, you'll find the list at page 30. pages 38 to 39 of my report,
Thank you.
the full list. So there's no need to go through it. So I'm just summarizing it in the slide 17.
On slide 18, Dr. Von Gernert, you carry on your point about Treaty 3.
Yes.
Could you take us through that?
So what these Anishinaabe expected was not a share of unlimited, unknown revenues drawn from the proceeds of the lands, but annuities and goods in amounts that would be identified in the treaty with incredible specificity. Like right down to the number of bushels of peas that a chief would receive every 8 years. I mean, they drew out the times they wanted it, the amounts, who would get what, in extraordinary specificity. So the type or manner of compensation was in fact acceptable to the Crown. This is the type of thing that was not, there's no concerns about the type. The real concern to the Crown was the amount. And so because each one of these demands had a monetary value that could be assigned to it, the Treaty Commissioner calculated, and this is now Treaty Commissioner Morris, the famous Alexander Morris, who wrote that book. He calculated that the annual expense of these demands was a staggering $123,112. So that's the annual amount that it would cost for the Crown to meet the annual demand. So he rejected it out of hand as utterly unreasonable. And it's interesting when you compare that amount, the 123,112, keeping in mind that 26,620 was the total amount expended annually for all of the pre-1850 treaties combined. So eventually, this was what Morris himself referred to as a long and protracted and difficult negotiation. And at the end of the day, the parties settled on a $5 annuity and other more modest terms than those that the Anishinaabe had originally suggested or claimed. So when Dr. Dribbin claims on page 54 of his report that, quote, one of the tenets of Anishinaabe culture is that children should not become a burden to their parents. Under the circumstances, it is Dr. Dribbin's view that the Anishinaabe did not want the augmentation clause to overwhelm the Crown. As usual, this tenet, as he refers to it, this cultural tenet must apply to all. If the idea is that you don't want to overwhelm the Crown with something, if that's something unique to Anishinaabe culture, then why do we have in 1873 a staggering amount requested, which demonstrably did overwhelm the Crown? Morris just said, oh, come on, that's ridiculous. There's no way the Crown's ever going to accept that. That's way too much. It did overwhelm the Crown, which unsurprisingly dismissed it as unreasonable. These are Anishinaabe people, okay, who are not that different from other Anishinaabe people of the 19th century. So if you go to slide 19, if a reconstruction of indigenous beliefs, expectations, and anticipations and views, these are all words that Dr. Driven uses, relating to the Robinson Treaties are to be based on human universals, purportedly unique Anishinaabe cultural features, such as the teachings of the seven grandfathers, etc., or such other broad factors as, quote, what the Anishinaabe understood to be their kinship, parent-child relationship with the crown, end quote, then we should expect these same universals, cultural features, and broad factors to have informed Anishinaabe expectations in other contexts. Again, this is a testable hypothesis. It is not as if we're in the dark here. If you make the argument, that's the problem with generalizations. We see this all the time in anthropological thinking, and we regard or we warn our students about it. If you're going to make the generalization, these are the consequences. You better be prepared to show how your generalization relates to the actual cases in the ground. Does your generalization bear it out? And in my view, this just doesn't. So examples like the Treaty Number 3 case, where we have an actual list drawn up by Anishinaabe leaders, in my view, should have prompted Dr. Driven to have questioned his opinions. I don't know how much Dr. Driven knows about these treaties or not, but so I give that as an example because I see it as one of the more dramatic instances where a generalization that is made doesn't hold when you compare it under the microscope of specific cases.
So do you say that on slide 16 that the suggestion that the Anishinaabe have or follow or believe or ascribe to the seven grandfather teachings, do you say that if they also are adherents of Christian denominations, that they no longer follow or ascribe to or hold as a close cultural belief, the teachings of the seven grandfathers?
Well, the teachings of the seven grandfathers are a very specific belief system that's related to the Maide religion. And then
But
the
I'm going to
Medieval
your evidence about diversity of religious beliefs.
That's right, yes.
And you started with and is Maide related to Medewan?
Yes, the
Okay.
Maide are actually the priests of the Medewan religion.
Okay, so I thought your example of diversity of religious belief was that while Dr. Driven said the Anishinaabe generally follow the teachings of the seven grandfathers, that there were Methodists and Anglicans and possibly Catholics. All right, and so my question to you, is that a diversity of religious beliefs? Can you say that? Or because are you saying that those adherents of these Christian denominations as a result of the arrival of the missionaries suggests that those Anishinaabe did not hold, subscribe to, follow, believe in the teachings of the seven grandfathers?
What I'm saying is that the Methodists and Anglican belief systems and this have their own stories about origins and about teachings and about morality and so forth. that may or may not intersect with similar ideals in the Medeowan religion. Anthropologists usually don't see indigenous religions as being completely supplanted by the newcomer religions.
I was talking about your evidence,
Yes,
not a
my-
background
okay, well,
explanation.
right, well,
But is your evidence that because there are adherents to these Christian denominations, that they are no longer holding and following, scribing to the teachings of the seven grandfathers?
well, in my experience, there are what we call religious syncretisms. That is, in some cases, once somebody converts, when an indigenous person converts to a non-indigenous religion, you don't necessarily drop all of their indigenous beliefs. They rather prefer a syncretism of them, and often, depending on whether the denominations or the leaders of the new religions are fundamentalists or more liberal, they tend to accommodate that kind of syncretism, right? So my point is not that it's a completely different religion and it's completely supplanted the original religion. It depends. Sometimes it does, sometimes it doesn't. It often results in a syncretism, where it's a melding or a merging of the two different religious traditions, right? But my overall point is that what constitutes religious diversity, or what constitutes Anishinaabe religion, is not one way of thinking, right? These are individuals who have adopted all kinds of different belief systems, and some of them are at odds with one another to the point where, you know, they also come to blows over religion like any other.
That's way beyond what I asked.
So, I mean, that's the only way to answer it, because I don't know personally.
I just wondered
each-
what you were saying. I
Yes.
wasn't going back to what you know. I was asking if that's what you were saying.
What I'm saying is that I can't rule out that some individuals continue to adhere to the teachings of the seven grandfathers after they converted to these other religions. I can't, you know, it depends on the individuals. I can't
So
preclude
you're
that.
speaking about it on an individual basis, not on a cultural basis.
Yes, there is, all I know is that there's no single Anishinaabe religion in the 19th century, just as there is not one today.
Thank you.
Dr. Van Gerden, at slide 20, you turn to Dr. Dribbin's opinions about the Crown understanding. Could you take us through that, please?
Yeah, so my point about his fourth conclusion is on slide 20. So even if one assumes that the Anishinaabe held the views about net Crown resource revenues that Dr. Dribbin claims, that is his first three conclusions, there remains the question of whether the Crown also held these views. So Dr. Dribbin's fourth conclusion reads, quote, that the Crown officials with whom the Anishinaabe interacted during the treaty-making process understood that the Anishinaabe held these views and acted accordingly, end quote. I looked in vain, however, in either Dr. Dribbin's report or in my independent research, indicating that Crown officials understood the RST Anishinaabe held the views on sharing as espoused by Dr. Dribbin. I just couldn't find it. I mean, laying aside, you know, the Anishinaabe side of the equation, I couldn't find any evidence whatsoever that the Crown officials acted accordingly based on these opinions. And in fact, quite the contrary, as I demonstrated in my Just Demand report, the Crown acted in accordance with entirely different beliefs, at least during the half century after the signing of the treaty. The only statement that Dr. Dribbin cites in support of this notion is an article by Professor Stark, and she doesn't speak to the Robinson treaties at all in that article. So I don't know where he's getting that from.
Doctor, at slide 21, you shift into dealing with Dr. Dribbin's specific critiques of you from this trial. And on slide 21 specifically, you deal with the criticism of Dr. Dribbin that you do not consider cultural variables. What do you say to that critique?
Yes, so this portion of my slide presentation deviates from my report, because when I wrote my report, I did not have obviously the benefit of Dr. Dribbin's critique on the stand. So this is in response only to my reading of the transcripts of his evidence. Now, with reference to the claim that I do not consider cultural variables, first of all, as an anthropologist myself, who sees human culture as being foundational to my profession, I mean, it's a definition of anthropology, is the study of human cultures. I would never deny or minimize the importance of cultural variables. I mean, that's just absurd. But one of the things we do learn early on, and that we later teach in universities, is not only that human cultures are diverse, but that each culture is internally diverse and changes over time. There's no culture that remains static. Indigenous cultures have never remained static. We know that from archaeological evidence thousands of years ago. Cultures were very different from what they were at the time of European contact. So my report does not fail to consider cultural variables, but stresses the diversity of views held by members of the same culture. And I address the flawed logic. That is, certain beliefs held by certain members of a culture are offered as synecdoches for an entire culture. A synecdoche is a figure of speech. So for example, if a soldier walks into a bar and somebody says, oh, here comes the army, that's a synecdoche. The soldier is kind of a stand-in for an entire army, right? Or Canada wins gold at the Olympics is the headline in the newspaper, but actually it's an individual who represented Canada in some way. So this is the flawed logic here. Certain beliefs held by certain members of a culture are offered as synecdoches for an entire culture. And then this general culture is then used to illuminate the particular beliefs of particular actors at a particular point in time. That's what I have an issue with.
And at slide 22, Doctor, you address a different criticism from Dr. Dribbin, and that's that Dr. Dribbin says that you viewed the treaty as a financial arrangement, What's your response to that critique?
Yeah, so, I mean, it's a fair critique to suggest, if anyone does so, that this is just a financial arrangement. It's not. However, to the extent that this treaty, like all Indigenous land cession treaties, contains a quid pro quo, which it does, they all do, it is undeniably a financial arrangement, at least in part. Right? You've got an extinguishment of Indian title to a defined tract of territory in return for a lump sum and an annuity. That's a financial arrangement. What I do not suggest at any time is that it's solely a financial arrangement. I would never say that. Like all Indigenous treaties that I'm familiar with, it involved two parties which had a history of unique relationships with one another. And those parties didn't always see the world in the same way. Natives and newcomers have always had unique relationships with one another. It's not like a financial arrangement that you might have between, you know, a crown official and a colonial settler.
Doctor, at slide 23, you address yet another criticism from Dr. Dribbin, and that's that Dr. Dribbin suggests that you viewed the treaty as a, quote, forever agreement, end quote. What's your response to that critique?
Well, as I understand it, he's complaining that I viewed the RST or what he's saying is that I should have viewed the RST as a static, not as a static, but as a living forever agreement. But nowhere do I actually imply that it was a static agreement. It was not. I agree, it was a forever agreement. There's no question about that. Especially since, unlike the earliest treaties, which just had a lump sum payment, you paid the amount, the parties went their separate ways, and that was it. There was no more obligation under the treaty. But once you get into the annuity system, that is a treaty forever. There is an obligation there that binds the parties, in which one party has to pay for as long as the sun shines and the rivers flow, as the wording was in the numbered treaties. So, of course, it was a forever agreement. There's no question about that. Now, Dr. Dribbin goes on to suggest that the RST was not cast in stone in the sense that its elements or goals would evolve over time. And he claims that the Crown perceived it the same way. Now, based on my own research on 19th century treaties, which I've engaged in for decades, the Crown generally understood that the parties were bound to the stated terms, and those terms could not be altered except in very inconsequential ways. And, a good example is that August 1st deadline for the RST annuity augmentation. Right? There's a clause in there that if you read it today and take it to mean a solemn promise by the Crown to pay no later than August 1st every year, well, that condition was breached by the Crown long ago, in the 1850s. But the fact is that that was such an inconsequential breach of the treaty because the all the parties understood that it was just not practical to have that deadline. Many of these Anishinaabe were in the bush. They didn't all come together on August 1st. There were some complaints that, they received them very late, but overall, there were practical solutions. So the stated terms could not be altered, except, as I said, in some inconsequential ways.
Thank you, Doctor. On the next slide, slide 24, you address another criticism from Dr. Dribbin, and that's his statement that you overlook the importance of kinship.
Yes.
Could you tell us your response to that critique?
Yeah, so in his words, I viewed the RST as, quote, a transactional relationship that's based, or excuse me, he claims that I should have viewed the RST as a, quote, transactional relationship that's based on kinship, end quote. So if I understand this correctly, and I must confess I don't understand it entirely, but what I gather is that Dr. Dribbin recognizes significance in the fact that the numerous Anishinaabe petitions, such as the one dated January 3rd, 1852, referred to the Governor General as father and the Anishinaabe themselves as children. In Dr. Dribbin's view, when the Anishinaabe referred to non-Indigenous persons such as Macdonnell, who, as you may recall, was a lawyer involved back in 1850, when somebody like Macdonnell was referred as a father's white children, this was merely a figure of speech. But when the Anishinaabe referred to themselves as red children, it is the expression of some type of kinship relationship with the crown. Now, I'm hoping I'm not misconstruing that, but that's the evidence that I saw in the transcripts. And there was, some to and fro about this. So I gather that that's what he thinks I should have viewed, this transactional relationship based on kinship. Now, I'm reminded of that memorial that I talked about in stage 1, where Shingmakons in 1847 wrote Lord Elgin, and he spoke of Queen Victoria as, quote, the great mother, who might one day want land for her, quote, white children, end quote. So there's Shingmakons using the term, great mother in reference to the queen, and children or white children in reference to the settlers or the non-Indigenous people. This did not mean that Shingmakons regarded settlers to be undeveloped versions of the queen. That's not what he understood at all. I mean, to me, that would be a fanciful interpretation.
Doctor, before you move on with respect to kinship, what I'd like to do is put on the screen in front of you the July 5th, 1847 memorial, just so we can identify a document in the trial record.
Sure.
And Your Honor, for the record, this is exhibit 1-1524 from the Joint Book of Documents.
1524.
1524.
Thank you.
And Your Honor, if it's helpful, we have printed copies as well.
It's helpful because my screen is on the other side.
We'll get the printed copy.
If it's just a brief reference, sir, I can,
Your Honor, the entire
and you've
purpose.
highlighted it.
You're right. The entire purpose is so that Dr. Bungern can identify
Okay.
it. So it's on the screen now, so we can go with that.
Go ahead.
So Dr. Bungern, do you recognize this document?
Yes, it contains a phrase that I just alluded to. I would have to see the top or the bottom just to confirm that it is the same document. If you could scroll it up or down. I discussed this memorial, as I said, in my earlier reports in stage 1. Yes. That's the one I'm referring to.
Thank you, Doctor. So, Your Honor, the whole purpose of that was just to identify that as Exhibit 1-1524.
Thank you.
Doctor, could we turn to slide 25, please?
Yes.
Where you expand on this concept of kinship terms. And in the first bullet, you talk about a concept called, quote, forest diplomacy. Could you explain that, please?
Yes. So this use of kinship terms has a very long history. Right from the beginning of the contact between natives and newcomers in Eastern North America, there were kinship terms used. So, for example, in the 17th century, the governor of New France would call indigenous peoples, or was called by indigenous people as Father Onontio, which was a name of an early governor in their, confused orthography. But it continued to be the norm to refer to any new governor of New France as Father Onontio. And the Haudenosaunee as well, that's a literature I'm very familiar with. Throughout the 17th century, they called the New York governor Brother Corlaer. And so this was part of the formal discourse of what ethnohistorians refer to as forest diplomacy. So the formal interactions sitting around the council fire between natives and newcomers, going right back to the early 17th century, was always accompanied by this kind of formalized language. And by using these formalities, indigenous people in no way understood themselves to be children in the sense of like immature or undeveloped persons who only had the potential to become fully functioning members of society with the capacity to handle their own affairs. So in my view, someone like Xingwakons, this guy who is of mixed heritage and an Anglican would never have thought this way. He and his people were proudly independent. And you may recall in the lead up to the Robinson treaties, he stressed over and over again his service during the War of 1812 as a ally of the British, and tried to convince the Crown officials that, of his valuable service to the Crown. He didn't think of himself as somehow as underdeveloped or with only the potential to become some kind of fully functioning member of society. These are, these are formal appellations. And the other thing I wanted to say is, well, I also recall, testifying on stage one about this, because Schoolcraft, Henry Schoolcraft, he was a very famous Indian agent at the Sault Ste. Marie, but he was an American Indian agent. He was on the American side. And he and Chingwakonse, came into contact. This goes back already into the 1820s. And Schoolcraft mentioned how Chingwakonse would show up at his office on the American side, and he would say to Chingwakonse, "My father." And Schoolcraft, when he recorded this in his letters, he said that this was the ordinary salutation.
Chingwakonse to Schoolcraft,
Yes.
my father.
Yes, would refer to the American Indian agent as my father. That's the first thing he would say when he walked to the door. He'd say, I think he used actually an Anishinaabe term like Nosa or something like that. But Schoolcraft, heard it as my father. Well, Chingwakonse was, of course.
Mr. Schachter.
Yes, I'm just wondering, is this in the report? If it's not in the report, is it in any of the documents that we can find so that we can, see the archival reference to Schoolcraft and Chingwakonse's discussions? Or is this just something coming up new?
Yeah, it's something that occurs to me, or occurred to me only after this came up in the testimony. We can easily find it. It's in my first report.
Okay, if it's in the first report, we'll.
No, not the first report. In stage 3, in stage 1.
Yes, that's fine.
Yeah.
We'll find it. Thanks. That's
Yeah,
all.
It's what you're saying is in the report, or there's a reference, or there's a footnote, or
what
you
I'm
rely on.
saying is in the report, and
Okay.
it's amply footnoted. Yes, so it would be in the first. Yeah, I remember talking about this early years ago. So yeah, so that this is part of the formal language that's used, and I wanted to point out also, as we move to slide 26, that in the January 3rd, 1852 petition, which Dr. Driven testified to at some length, where we see the terms like father and white children or red children, I wanted to point out that this petition had been prepared by the Jesuit Jean-Pierre Chaunet, about whom I have spoken on several occasions. I very much doubt, well, before I say that, this, as in many other petitions, gives us a bit of a quandary, because it's uncertain whether the Anishinaabe were actually the ones using the term, or whether they were simply introduced by the writer mandated to convert the views into a formal discourse. we don't know exactly in relation to this particular petition, which of those options it is. But one thing I can say for sure, it's highly unlikely the Anishinaabe would have used the term red children unless they were simply appropriating it from language, thinking that it was also part of the formal discourse. The adjective red Indian, but the red in front of Indian or children or whatever, that the use of the term red is particularly striking here. The adjective originated actually with reference to the Beothuk. These are people that I studied in relation to the Drew case in Newfoundland. And they had a very early contact with Europeans, and the Beothuk actually colored their bodies red, literally, with red ochre. And so many of the very earliest descriptions of these indigenous populations of Newfoundland referred to red Indians. And then from that time on, it sort of entered the discourse of native newcomer literature, and it was still widely used as a more general term throughout much of the 19th century. It was in common usage. And we know that other literate officials who prepared petitions on behalf of the Anishinaabe had different preferences for formal communication. So here I just wanted to point to my Just Demand report at page 330. And we looked at this yesterday, so there's no need to go back to it. It was that November 1877 Anishinaabe petition that was prepared with the assistance of Edward Boron. Remember, it's that printed page that he helped them prepare. And there's no references at all there to father or children. None. It's addressed to His Excellency Right Honorable Earl Dufferin, KCB, Governor General of Canada. So, here is an example where, Boron, who's got, a slightly different understanding of what might be the formalities to use to address the Governor General, might be when Anishinaabe people petitioned the Governor General. And lastly, I point out that other formal language in the 19th century, didn't necessarily reflect expressions that are relative to status or expressions of relative status. So, when you read all of these letters, you keep encountering this one thing at the end of each one, the closing valediction, your humble servant. And it doesn't matter whether it's a superior to an inferior, or, these are just norms that people use, a polite form of salutation. Overall, I think Dr. Driven makes way too much of this kinship point, which almost to me seems mildly offensive to suggest that, Anishinaabe peoples thought of themselves as children, or who needed to develop over time before they became more fully adults and on par with the non-Indigenous crown.
Thank you, Doctor. That was your last slide. Is there anything else that you'd like to communicate to the court in respect of Dr. Driven's critiques of your work?
No, I'm pretty much exhausted at this point. I hope I have been of some assistance. I mean, sometimes this whole process has been more one in which I've learned a great deal, and it's not necessarily that everything that I've learned may be of assistance to Your Honor, but it's, you know, I tried to do my best and bring the best scholarship to this as I could.
Thank you, Dr. Von Garnet. And Your Honor, this concludes the examination in chief.
Thank you very much. And this concludes the day and the week. As council will tell you or may have told you already, there is an understanding in the system or obligations in the system that you do not talk to anyone about your evidence during cross-examination. I raised, because there was some reference to this yesterday, that we're not in cross-examination yet unless Mr. Oh, was anyone else going to jump into asking questions in chief?
No, Your Honor.
Okay. Okay, thank you. So you're not in cross-examination yet unless someone wants to start it. But this period between examination in chief and cross-examination is sometimes considered a gray period. And I would prefer, unless I hear submissions contrary to it, I would prefer you not discuss your evidence with anyone now that examination in chief is completed. Do you have anything?
Your Honor, that's fine. We've taken a very cautious approach to begin with. So
Right.
we're happy to treat this period as if Dr. Von Garnet is under cross-examination.
Thank you very much.
I'm leaving town anyway.
Well, I expect actually most people won't be talking about the evidence too much on the weekend, so that is just as well. Oh, sorry. Some people will. But on this side of the table, sure, everyone is quite happy that it's over for the day and for the week. Thank you very much. We return on Monday at 10 a.m.
Correct, Your Honor.
All right. And I'll hear from you then, council. Presumably, you know, you may have had some, you will have had some time to prepare, and you can make your views known on what you think of the time that we have scheduled. Okay. All right. As usual, my fervent wish is that you travel safely, that you stay healthy, and that I see you all on Monday.
Oh yay, oh yay, oh yay, the sittings of this court have not concluded. On with the day.